Good afternoon, everyone. This is Mark Askelson. I'm from the Compliance Group. Thank you very much for joining us today on how not to fail your HIPAA meaningful use audit. From a little bit of a housekeeping perspective, a couple things today. This recording will be made available. Usually it takes us a day or so to get it posted, so if you go to the Compliance Group /webinar site, you can see both upcoming and past webinars. The next webinar we have coming up is going to be controlling your online reputation before it controls you. We'll be doing that jointly with doctors.com. That'll be on October 22nd from 2 to 3 o'clock. For the webinar, please do ask questions. It makes it a lot more interesting for all of us and I think more informative for the attendees. I will be, basically you can post the questions on you should have your panel on the right-hand side. I will, depending on who's speaking and where we're at, I will either interrupt us or I may hold them until an appropriate gap in between the various slides. Okay, so how not to fail an audit. So for today's lessons, we're going to try to have a little more fun with you guys today. We do several of these a week, so every once in a while we try to mix it up a little bit. So we're going to talk about, are you compliant? What is the big misconceptions we see? Then Bob Grant, who will be introducing himself shortly, will go into much more deeper of what are the audits that are coming or potentially coming your way, what are the actual things you need to be doing or not doing, and then we'll close up with questions and answers. So let's play a little game. Are you HIPAA compliant? So I'm going to ask you a question, and well, you guys aren't really going to answer, but I'm going to answer for you. So policies and procedures. I have a manual. That makes me HIPAA compliant, right? We hear this all the time, very common when we hear from associations. Unfortunately, depending what your specialty is, no. If you just had policies and procedures, whether they are brand new, written by your lawyer, given to you by your trade association, unfortunately, with just HIPAA policies and procedures, you would fail an audit. And we'll talk a little bit more why. Okay, so next up. I have purchased this incredible workforce training program. Everybody is trained. We all have certificates. Therefore, we're compliant, correct? Unfortunately, the survey would say no. Same thing. If you just did workforce training, whether they're very common, people will inadvertently do these things. They get a training. Unfortunately, if you are not doing, and we're going to talk more about what all the things you need to do, but having a training program is not enough. Okay, so next, I had an expensive security risk assessment done. Am I compliant now? You might ask yourself, so great, especially for folks dealing with meaningful use. The answer would be, unfortunately, no. If you just did a risk assessment, you would fail a HIPAA audit. And we'll talk a little bit more about kind of the trends we're seeing in the industry and what's happening. So the big misconception, or one of the biggest misconceptions we see, and we see this also from the perspective of our clients and in the industry, is that a lot of people believe when they are tested for meaningful use and they did a security risk assessment, and or that their provider, the HR platform that they're using, that they were HIPAA compliant. Unfortunately, that's not correct, and we'll talk a little bit more about what those things are. In the end, what you're going to see, the federal government, OCR, which is the regulatory arm of HHS, and CMS, which is the regulatory arm of meaningful use, the respective failure rate that they are reporting is 70% for OCR or for HIPAA, and 79% in the meaningful use arena. Okay, so let's talk a little more. So what are trends we're seeing? Okay, what are the trends we're seeing in HIPAA? So the first one we saw, I just want to think is kind of an interesting and timely fact, was last week, Fitbit, which for those of you who know who they are or don't know who they are, they're exercise tracking devices. Fitbit has done a great job working with a lot of corporate programs, working with a lot of medical insurance companies that, if you have a Fitbit and you are exercising a certain amount, they have all sorts of great returns. You get incentives. What Fitbit did this week, which was very interesting, was as a business associate, and we'll talk about what that means a little bit there, they made a big splash in a press release announcing that they were officially HIPAA compliant and that they were now willing to sign BA agreements. Okay. Now, in the compliance world, there's been a lot of debate about, you know, how serious is this and how meaningful is this. But in the end, I think it was actually a brilliant move by what is their executive team, and an illustration of a trend that, at least on our side at Compliancy Group, across the thousands of clients that we work with, we're seeing a definitive trend. And that is business associates as well as doctors' offices are going much more, or recognizing that by HIPAA compliance is a differentiator. Okay, it is, you know, patients are acting much more like traditional retail consumers. They're doing research on you, and depending what they see or don't see, they are judging whether or not they're going to use you as their provider, whether you're a business associate or a covered entity. So another thing that we hear a lot, you know, we've heard for many years is HIPAA compliant, it's toothless, there's not a lot of enforcement, why do I have to worry about this? Is just as an interesting point of information, from 1996 to the end of 2014, the federal government, or OCR, which is the enforcement arm of HIPAA, only levied $14 million in fines. And it's true, through that time, the fines were primarily based on an incident occurred, and therefore, because of that incident, an investigation was done and a fine was levied. 2015 has been very different. There was a new head to the OCR. The director came out of the legal community. What she has done is a couple of things. On the enforcement side, she has levied, or her organization has levied, over $11 million in fines in just so far this year alone. Interesting things about that, Oz, you know, the days of it was a traditional hospital or larger medical clinic is no longer correct. This year, you know, we saw a dentist get fined and actually lose their license because of mishandling of medical information. A pharmacy in Colorado gets fined $125,000. A nonprofit in Alaska gets fined $150,000. Last week we saw an oncology group get fined $750,000, and then in Texas we saw one hospital get fined for $4.4. Another thing that's been kind of interesting, well, you know, it's a fine. How bad can that be? This year alone, so far what's been announced, there's been at least 3 prison sentences. A CFO who was sentenced for 23 months in jail, and then 2 other incidences where the person involved who had perpetrated the incident, the violation of HIPAA, was put in jail. Both sentences were 24 months. So we're seeing a lot more of this. The very last thing that I think is just, and this goes back to the point of what we're seeing in the consumerism shift in the U.S., is the Anthem Blue Cross breach, which, whether you were affected or not, the translation of 79 million people's PHI getting violated translates to 1 in 4 Americans this year had their PHI violated. And 2 very important things to stress in that violation, or I'm sorry, as part of that process, for those of you who are, we'll talk about breach notification, they were forced to send a bunch of letters, but 2 of the letters, which I think are very problematic, and they're enlightening depending how you look at it, problematic for some, is that what it said was the two of the letters said, one said, you know, your PHI, here are all the rights you have, and here are the rights you have to the access to your information, that your doctor's office and the people who touch your PHI, the obligations they have to you. And the other one said, this is such a big deal, you will get 2 years free of credit monitoring service because of the fear of identity theft. It is definitely, there are a lot of interesting trends that have happened in 2015. I do think you're going to see a continued upswing on that, and I'll leave it to Bob to talk a little bit of some of the changes that were done or announced or as part of the Stage 2 audits. Let me transfer this back over to Bob, and we will continue this presentation. By the way, like I said, please do ask questions. You don't need to wait till the end.
Well, good afternoon, everybody, and thanks, Mark, for that. My name is Bob Grant. I'm co-founder of Compliancy Group and co-author of The Guard, which is a tool to help organizations comply, but that's neither here nor there today. Today we're going to talk about regulatory acts and what you need to do to be compliant. Not only to be compliant, but to show compliance to any federal agency or any of potential customers who ask you now, about your HIPAA compliance. What I found is in talking with a lot of practices lately and a lot of business associates is that they're amazed at the amount of people that are asking them for how are you complying with HIPAA? What can you show me? Show me what have you done to protect my data? And some of them don't have anything. And that's why they contract to get this information that I'm going to show you today in place. So if you're sitting there and I start talking about things and you go, well, we don't do that. We don't have that. Well, let me just say this right now. You're going to need it. At some point in the next year, year and a half, you will need this, because I just want everybody to know that HHS just hired a company out of New Jersey to do stage 2 audits for HIPAA, meaning that they're going to start doing desk audits, they're going to start doing on-site audits, unannounced, and it's going to start shortly. I think one of the things why they may delay for maybe a month or two is because of ICD-10, but be assured they're going to come on site and they're going to ask you for specific documentation to help you so that they can say, okay, you're making a good faith effort. Just so everybody knows this, before I get started in this, I just want to say this. The rule doesn't say you have to be compliant. Nowhere in the rule does it say you must be 100% compliant, because you can't. So when people tell me and I ask them, well, are you HIPAA compliant? We are 100% HIPAA compliant. Oh, no, you're not, because things change. Every day something changes in your practice or your business associate, or if you're a business associate. You get new employees, you get new equipment, you get new changes, you have this going on and that going on, which causes a deficiency. And when the deficiency happens, now you're not compliant anymore. When you're not compliant, and as you keep going down that road, that little bit of non-compliance can turn into neglect. And that neglect can turn into willful neglect. And so as you go down that path of non-compliance, it starts off at maybe $100 an incident, or maybe $10,000, but then it starts going to 20 and 50, right, per each incident. So you have to be really careful that you stay on top of your compliance and that you document. So HIPAA is a giant animal. I mean, it's huge, right? That's why they have that HIPAA, because it's huge, right? And inside of HIPAA, there are other types of acts that you have to worry about. You have to worry about Omnibus. Omnibus was the inclusion of business associates into the fold. When HIPAA first came out, you didn't even have business associates, so you didn't have to worry about it. But then all of a sudden, business associates started breaching everybody, and the government went, wait, we got to get these guys in here. So they created Omnibus. Then they had, okay, so now we've got HIPAA and we've got this Omnibus, and people were still getting breached, but they weren't reporting it. So they created HITECH and said, HITECH says if you have a breach, depending on how many you have and depending on at the end of the year, you have to report these to us. We need to know. And once the government knows that you're having breaches, they're going to audit you, because they're going to want to see if you're compliant or not. Then they said, okay, let's do this. Let's take this electronic health record and let's get it pushed out to everybody in the United States. So we're going to give you money to do that. Okay, fantastic. I'll take that money. I'll put in that system, right? And they did. But little did they know that inside by taking that money, you agreed to follow their rules. And one of the rules was you have to have a risk analysis. And then stage 2 says you got to fix everything you found wrong in stage 1. So they're kind of going backdoor to make you do HIPAA compliance. When Mark was doing those things about, if you have a policy or if you have a risk analysis, the answer was I needed all of that. I need to have every bit of what he was saying to be able to show my good faith effort in complying with the rule. Remember that. Good faith effort, due diligence. That's what that means. I'm looking at it daily. I'm making sure that everything's in place. Okay? I have to make sure that from the privacy aspect, that if I'm a covered entity, that I have authorizations and disclosures and all of that goes along with how am I protected. Remember this, it's all about protecting the data. The more you protect the data, the better off you're going to be. So if somebody asks you to do something from the outside, you get that authorization and disclosure form. You get that patient to sign. If you receive a subpoena about a patient and it tells you we want you to release this information, you contact that patient. You say, hey, I got a subpoena, I have to release that. You have to give them the opportunity to say, don't release that information. So the more private you keep this information, the better off you'll be. Okay? Now, comes to the security side. You have to make sure that you're securing it. You have to make sure that if you're sending emails, that your emails are encrypted. If you're right now sending emails out there and you're just, I have text messages I'm sending to the doctors and I send them an email about a patient, you're breaching. Little do you know that everything that you're doing like that is you're breaching the data every time you send one of those. So you need to have, why you have to have a risk analysis. The risk analysis is basically showing you all the deficiencies that you have when in trying to protect the data. So for example, where can I have deficiencies at? Well, my workstations may have deficiencies. For example, I may not have antivirus on all my workstations, which allows a hacker to hack in and come in and put sniffers on that device, which they could actually see the data that's on the screen. So you want to have antivirus on each computer system. Your servers have to be protected. The rule is you have to encrypt data at rest and data in motion. Sometimes that's not feasible. Sometimes you may not be able to do that encryption at the server because maybe everything else shuts down. Well, then, okay, that's fine. If you're not going to be able to do it that way, then you've got to physically protect that data. I can't tell you how many people now still today that have their server underneath the front desk. No protection, no nothing. And then you say, okay, well, great. If that's where it's at, that's where it's at. Well, okay, so you have an alarm on your building, right? No, we don't have an alarm. Well, see, here's the deal. Here's the deal with alarms. And people will give me grief about this all day long. And I actually tell people, you have to have an alarm here. Why? Because if you have a 4-day weekend and you come back to your office and it looks like Cindy Lou Who's house after the Grinch has been there, and all there's left is little things dangling off the wall, how are you going to explain that to the government you were protecting the data? Because they're going to say to you, well, what happened when the police showed up? Well, they never showed up because we didn't have an alarm system. Were you protecting the data? Absolutely not. You're going to face a fine. And it's going to be X amount times how many patients are on that server. So now if that server wasn't encrypted, now you've got even more problems. So having a risk analysis that identifies the deficiencies and then having the deficiencies remediated, fixed, helps to show the government that, again, I'm making a good faith effort. Again, we've talked about the breach notification, right? So if something happens over here where it got breached, then you have to worry about, do I have to notify? If you say, I'm just going to cover my eyes and not do anything, I'm not going to send this out because I know what's going to happen if I do. Let's say that your patients that got breached, their identities get stolen, and it comes back that it was you, and you knew about it, and you didn't alert. That's $50,000 per each one of those patients. So if it was 10 patients, that's $500,000. So hiding doesn't help. Not doing the security and the privacy side doesn't help. You need to make sure that you're doing it. Now we get to the point of, how do I survive this audit? Well, what you want to do is you want to look at your individual organization by regulation. Each one of these has a set of regulations by number. And so the number says, 164.308A1 says, I need to do this. And A2 says I need to do this. So you need to say, am I doing that? And then do I have the documentation to show that I'm doing it? Well, I'm going to say this right now. 80% of it is you have to have the proper policies and procedures in place. And you have to have your staff attest to it. Now, I'm not talking about, when I say attestation, I'm not saying put 50 people in a room and start talking about some regulations. Because you know what's going to happen? There's going to be 3 people in the back playing Candy Crush on their phone, 4 people looking out the window hoping for the weekend, and they're not attesting. They're just going through the motions. They're the ones that are going to breach you, and they're the ones that are going to send you down that road to have to pay. So what you should do is you should make them individually attest to the policies and procedures and hold them accountable to it. If you're not doing that, you're going to run into problems. This is where, as we were talking about before, there's HIPAA, there's meaningful use, and there's HIPAA. They're intertwined, right? They're intertwined. But HIPAA is the overall arching part of this, right? They're the ones that are going to come and fine you. These guys over here, they're going to ask for their money back, right? And if you fail their audit, they also can send notification to HHS, right? But to me, this is the smaller side of compliance, right? Yeah, I want to keep my money. Yeah, I want to make sure I have my EHR. Yeah, that's good. The other side is this HIPAA one. Now, when the HIPAA police start coming, what's going to happen is they're going to start asking for money. Okay? If you haven't audited yourself against the rules, privacy, security, breach notification, if you don't have the proper policies and procedures in place for privacy, security, breach notification, if your staff isn't properly trained, and I'm not talking just some HIPAA 101 training course, I'm talking about them attesting to the policies, procedures, and the HIPAA 101 training course, and you can't show it to them, they're going to sit there and they're going to make their own judgments. What you want to be able to do is say, here it is. Here's my risk analysis, here's my risk management, here's my policies and procedures, here's my training, here's how my people have been trained, and here's all their documentation for it. Ta-da! Here's my risk analysis. Ta-da! Now, what do you think? And let them make the decision. But don't leave it up to them to say whether you're compliant or not. You want to say, I am making a good faith effort, and I am showing due diligence, and I am proud of it, right? But if you sit back and shrink down like a violet in a hot day, they'll come down on you like bricks on a house in a tornado. When we start talking about the attestation for meaningful use, stage 1 meaningful use is starting to end, right? They're going to stop giving money out for it. Some people have still gotten in, some people haven't. But what you have to make sure, number one, is that these little core requirements that they talk about, right? So there's 13 for stage 1 and 17 for stage 2. These core requirements that people got, they got a checklist. And so doctor's office got this checklist, they looked at it and they go, well, that's the EHR, that's EHR, that's EHR, this risk analysis, that must be my EHR company also. I'll tell you right now, 70% of those people had to give their money back because they didn't do a risk analysis. That's because their EHR company didn't explain to them, and they didn't understand what a risk analysis was. They just assumed. And what happened was the government just came and they took the money back. Stage 2, one of these core objectives is you have to do risk management. Risk management was taking everything that was found from stage 1 and making sure that you remediated it in stage 2, that you fixed it, and you had the documentation for both. You had the risk. Here's my risk analysis. Here's my risk management of how I fixed everything. And then by doing that, you were able to give that information to CMS, and they gave you the second part of the money. Some people had to give back the first part, never got the second part. When we talk about phase 2 audits, the government has felt it's been long enough for business associates to have gotten into the fold and become compliant. Now, covered entities who have to do privacy, security, breach notification, the IT risk analysis, a device audit, and a physical site audit, right? They have to do 6 of these. The only thing a business associate doesn't have to do from what a covered entity does is they don't have to do privacy. They only have to do the one privacy thing they have to do is breach notification. Otherwise, they're just doing security. So as you go through that, as what you're going to see here is that they're going to start doing these desk audits. And what a desk audit is the same thing for some people who are out there, and if you've gone through a CMS audit, is you got a desk audit. You got an email that said, hey, we're auditing you for Stage 1, please give us your risk analysis information. And so the same thing's going to happen with HIPAA, but it's going to be worse. It's going to see, okay, it's been 10 years since the HIPAA rule was out. Please send us your documentation for your risk analysis, your risk management, your policies. Give us some procedures. Give us this. Give us that. And so it should your plan should be pretty robust at this point. Some people aren't. Some people even done it. It's 10 years. So for the people who stuck their heads in the sand like an ostrich, they're going to come down hard on them. And so within the next year and a half, you're going to see some mom and pop and single doctor practices with 2 people. You're going to see those people who have had, they're going to get big fines. Before I get started to the 7 fundamental elements according to HHS, Mark, are there any questions?
Yep, we got a couple. So, one, okay, what is the best way for covered entities to confirm their business associates have or are in compliance?
That's fantastic. Okay, whether you're a covered entity or you're a business associate. Now, what was that question again? Were they talking about their covered entities?
So, what is the best way for them as a covered entity to confirm their BAs are in compliance?
Okay, so there's 2 types of BAs, right? There is the covered entity has business associates, and let me tell you what a business associate is because some people don't even know that. Okay, number 1, a business associate is anyone that you hired. You physically hired them and give them money to do something for you. That would be somebody like a clearinghouse, a collection agency, your EHR, your shredding company, your storage company, consultants, right? You hire them to help you do something and you give them money. And you give them access to protected health information. So, as you give them access to protected health information, they become a business associate, whether you're directly giving it to them or giving them access to it. So, the best way to do that is you're going to send the business associate a new up-to-date business associate agreement, and you're going to have them sign it, and you're going to audit them. Now, people will balk. Business associates will balk. If there's business associates on here, well, we have our own business associate agreement. Okay, fantastic. Well, sometimes your business associate agreement isn't, in my opinion, fair, right? Your lawyers write business associate agreements, and it should be a fair situation. It should say something like, if you breach, you pay, I breach, I pay. And a business associate who is dealing with protected health information should be willing to give you that documentation, whether they're complying with the HIPAA security rule or not. So you send them a HIPAA audit, a security audit. And the security audit, basically, you either ask them for documentation for it or you have them fill one out. It should be a robust plan. It should cover, risk analysis, risk management, policies, procedures, training, and things like that. And then that's how you do it because, look, you don't want to end up as a covered entity in a situation where you're sharing information with a business associate, they get breached, they weren't complying, you have no documentation from them that you asked for that documentation or they provided it to you and they lied or whatever. I'm not saying that business associates lie. I'm just saying you have that documentation to give to the government that says, I shouldn't be involved in this because I asked them for the information and this is what I received and that's why I continue to share data with them. Same thing if you're a business associate on the call. If you're a business associate, you have business associates. It's kind of like a chain, right? Covered entities at the top, next business associates here. And if that business associate is sharing with somebody else, you need to do the same thing. You need to make sure that the business associates below you are all compliant too, and that they're following the rules. Why? Well, because as you are sharing this person's data from above you with them, they may be sharing with other people, and you need to make sure that they're doing what you're doing. Otherwise, if a breach happens, it's just gonna go up the chain, and then you, the one who got the data from the covered entity and shared it, you're the one that has to report to them. You have to say, well, this business associate that I have down here breached all your data. That's not going to go well for you. So you want to make sure that everybody below you also is complying. Other questions, Mark?
Hey, Bob, this is actually, I think you've kind of addressed it, but the question was, does a BA or should a BA confirm that their covered entity is compliant?
No,
So the other way.
not their job. You have to make sure that you have a business associate agreement in place with them, right? So let's say you're a BA and a covered entity hires you to do something, but they don't send you a business associate agreement. The omnibus law requires you to get one in place then. If they don't send one to you, you send one to them. It requires both of you, both parties, to have a business associate agreement in place, whether it comes from the business associate or it comes from the covered entity.
Hey, all right, so the next one is, how often should you update your business associate agreement?
Your business associate agreement should be up. Your business associate agreement should be reviewed. It should be updated if the rule changes. It should be reviewed every year. Not resent out, not re-signed, reviewed. What you need to do is you need to look at each individual business associate you have, look at the contract you have, and say to yourself, does this business associate agreement still cover what I'm doing with this person? It does? Great. Let me put a date down here, reviewed on 9/29/2015, right? And you have to do that every year, okay? That's how your business associate agreements work. It's up to you to determine how often you want to audit them. Now, if the relationship changes, that's when you're going to want to have a new business associate agreement in place.
All right, a couple more. This one was a question that you just made a comment about a server, but you talked about a server under a desk. So if the server is encrypted and all the backups are encrypted, will that count as taking necessary actions?
Yeah, it will. It will, but they're still going to question you on. They still would question you because if that happens, you still, even though it's encrypted, you still have to report. Okay. So when you go to report, they're going to say, well, what about your physical security? Why didn't that prevent this server from being taken? For example, they could have said you could have put a cage under there, and you could put it in a metal cage there, right? But it's just sitting there in the open and no alarm systems on your site. They're still gonna they're not going to get you for willful neglect, right? Because that's just the way it is, right? But they will get you for some type of maybe a corrective action plan, right? It just behooves you to think more, and for everybody online to think more, how do I protect these patients' data more effectively and make sure I'm doing it?
We have a couple more. You guys can keep adding them, and although we may start back up again, but let's get through the ones we have. They're great questions, by the way. If we refer out to the physician's offices, if we refer out to other physician offices, are they considered to be business associates?
No, they are not. That's a great question. A lot of people get confused on this one. You can freely share data. You can freely share data with. You could freely share data with anybody for treatment, payment, or operations. So treatment would be like for referring physicians, or you're sending information to the hospital about a patient who's going to have surgery. Payment, insurance company calls you and says, I need more documentation about this patient for this service that was done so that we can pay you. Great. Operations, insurance company wants to come out and do a chart check, right? You can, come on out. You can do that because you can't bill them without them doing it. So operations you can share, okay? Anything else falls under authorizations and disclosures.
All right, this is a really interesting question. The person who posed it, I actually kind of love it. Bob, this will be interesting to see you answer it. Okay, so do you honestly think that HIPAA has been a good thing overall? Computers get hacked or stolen, professional staff still accesses records they shouldn't, and many get away with it. It seems like there is so much cost to the medical facilities, and it all causes more work. Do you agree?
I don't. I think it's a great thing, and I'll tell you why. As a consumer, right? I don't. From a healthcare standpoint, is there extra work to do? Absolutely. I'm not going to lie there. But from a consumer standpoint, let's step back and see, why did HIPAA come into play? right? I think this is a great time for this, okay? And I love telling this story, all right? So why is HIPAA here? That should have been the question. Why do we even have this? What caused all this, right? Well, in 1996, right around there, hackers and people were killing the banks. They were going in, they were taking people's data, stealing identities, and the government said, you can't have this. We can't have this. So they created a law called Gramm-Leach-Bliley. And Gramm-Leach-Bliley basically made the banking industry do what you do now. Okay? So the banking industry was a mess. Their IT systems weren't right. Their security was wrong. Everybody was getting in there. Everybody was using the data for whatever they wanted to, and the government put a stop to that. At the beginning, no one wanted to do it. Kind of like HIPAA. Huh? Sound familiar? No one wanted to do it. They dragged their feet until the government started fining them. And they fined them heavy, $1 million a month. If you didn't comply and you were found to be non-compliant, we're going to fine you $1 million a month till you're compliant. Well, the banks went, oh, hold on, and they became compliant. Kind of like what the government's going to do to healthcare right now, okay? So what happened was when the banks became secure, the hackers said, where do I go now? How do I get this data to make my living, right? So they went, where's the next best place to go where people have all their personal information, they've got credit card information, they've got checking information. Well, let's go to healthcare. They're not compliant. So they went in and started doing it to hospitals and doctors' offices and stealing things just like you said. So then they took that information and they started stealing identities. So the government said, whoa, wait a second. Let's just take GLB, turn it into HIPAA, and make healthcare do it. Great. And so then all of a sudden, there's the law. And they expected healthcare to follow. But guess what? Healthcare didn't. They dragged their feet just like the banks did. But it's taken the government a little longer to start this program up of how they're going to fine you. But they're going to fine you, and they're going to come on hard. But is it a good thing? From a consumer's aspect, yes, it is. Because you have the hospitals, doctors' offices, they have more protected information than almost any other industry in the United States because there's almost 7 million of you. That's 7 million chances for hackers or somebody dishonest to get in and get that information. And so to protect the public, I think it's a good thing.
All right, because we are, why don't we get back to some more of the slides and then we can get back to questions after that.
Okay, so the government put out these 7 fundamental steps, right? And it's everything that I've just been talking about. First off, you have to have written policies and procedures. And you have to have standards of conduct. That means it's a sanction policy, right? The standards of conduct policy says if you breach the HIPAA federal regulation, we can fire you. If you put our practice in jeopardy, you're gone. Now, the only way that this standards contract works is if they've understood the policies and procedures, which means they need to go through and attest to each individual policy, right? Because easily somebody could say, well, did you sit through that class? Did you know? I was so bored I fell asleep, right? Rather than them having the opportunity to tell you if they understand something or not. You have to have somebody in charge. Even if you're a one doctor practice with 3 employees, somebody's got to be the compliance officer. Somebody has to be responsible. Somebody has to be the person the government goes to when they come on site. That is either the compliance officer or security or the security officer or privacy officer. You could have one compliance officer or one privacy and security officer. You have to have training and education. It has to be done yearly. You have to make sure that your employees understand that what the rules are and what the rules are here about HIPAA and how to protect the data. If you're not doing, see, as you can see here, as Mark was saying before, if I only have policies and procedures, I'm missing all this. If I only have training, I'm missing all this. You have to be able, your staff needs to be able to come to this compliance officer and say, oops, I did this wrong. The government knows everybody has incidents. Whenever I talk to a practice and I say, well, how many incidents did you have this year? Oh, we didn't have any. No, you had them. You just didn't know about them. You didn't know about them because there's no lines of communication, right? It has to be, it's okay that we had something happen. Just let me know so that I can fix it. Everybody has them. Everybody's got a fax that went to Joe's Bar and Grill. Everybody's got an email went to the wrong place. Everybody's got, ABC, things that are going wrong. You just, the privacy compliance officer, whoever it is that's in charge, needs to know so they can address it. If you hide it and you bury it, it's going to get dug up. You need to have that audit. You need somebody to do a risk analysis to tell you what's wrong. That's not, in most situations, in a regular doctor's practice, they do healthcare. They don't do security. They don't do privacy. They do healthcare, right? But when somebody comes out and tells you, you got to do it this way, you have to do it this way, you have to do this, and you have to do this, they'll follow it if they know what it is. So that's why you have to do this audit, to find out what it is you don't know so that you can do it properly. The disciplinary guidelines, again, that is just people following the right processes, the right procedures to make sure that you're protecting the patient's information. And so then at the bottom here is is incident management, right? If you do have an incident, which you found out from up here, then you're going to want to make sure that down here that you investigated it properly, passing your audit. When they come and they ask you for that stage 1 risk analysis, it has to be done within the last 12 months. Okay? And then for stage 2, whatever you found wrong during the risk assessment, you need to make sure that you have remediated it or fixed it. And you need to track how you did that. Like I said before, 80% of it is these policies and procedures. And the policies and procedures must be updated sometimes within a year, depending on what state you're in. If you're in Texas, California, Michigan, Florida, New York, it's every year. If you're anywhere else, it's every 2 years. If you say, oh, I got a binder up here, yeah, I think the policies were written 4 years ago, you're in neglect. You're probably close to borderline neglect. So that 3-ring binder that's up there that you think that's going to save you could possibly get you more fines than you wanted. You have to train your staff every year. So you have to have an audit every year. You have to make sure you review your policies every year or 2 years. You have to make sure your employees are trained every year. So there's certain things you have to do every year. You have to review those business associate agreements. So there's stuff you have to do initially, and then there's stuff you have to do every year. Again, we just talked about the business associates, right? This is a really great one right here. Any device within your organization that connects to protected health information or stores it we need to know where it's at. We need to know how you're protecting it. We need to know if it has antivirus on it. So there's certain things you have to do from a technical standpoint with those devices to make sure that the data is being protected correctly. Why do I need to know where it's at? Well, the reason why you need to know where it's at is if that system goes out of service, like, hey, we bought a new computer for Joni at the front desk. Okay, great. Well, when that computer gets taken out of there, a couple of things have to happen. Before you can get rid of it, you need to make sure that the hard drive's taken out and shredded, so that if there's any electronic protected health information in there, that it's gone. Now, you can go through and get a special software that's approved by the Department of Defense to have it wiped. But then again, what are you going to do with that, right? So if you're going to donate it and they need the hard drive, maybe you spend the extra money and get all the stuff on there deleted. My personal thing is you just take the hard drive out and throw it in the shredding box and let them shred it. You also need to review your compliance plan yearly. All of this that we talked about before I go to the next page, all of this that we talked about before, let's review real quickly. What do I need to have in place? Why is it that, and I'm just going to make a statement here, Compliancy group customers who have been audited by CMS and HHS have all passed. Why? Well, the reason why they pass is because they can show due diligence. They can show they are making a good faith effort in complying with the rule. Okay? And this is what everyone should be able to show an auditor. Number one, you should have up-to-date policies and procedures in place. You should have training records of your employees that they have attested to the policies and procedures and they have taken HIPAA 101 training. You should have a risk analysis done that identifies any deficiencies within your organization for firewalls, routers, servers, desktops, wireless routers. You should also have a device audit that shows every place that computers are that are connecting to PHI and how are they being protected. Are they encrypted? Do they have remote disk wipe, especially for laptops, right? How are you protecting the data that they're accessing there? You should have a risk analysis, right? You should have a physical site audit. The physical site audit, it says, how are you protecting things within your four walls? Do you have an alarm system on the building? Do you have, is your server protected? You got this new EHR system that they said to you when you bought it, hey, we're going to make you paperless. And now you're printing more paper than a forest. What's happening to that paper? Is it getting shredded properly? Is it sitting in the box overnight? Do you have a cleaning service? You need to address all those issues of anywhere where protected health information is. How is it being protected? So and then you need the training side of it. So if you have all of that in place and you can show it to the government, they're going to look at it and say, you have a compliance plan going on here. And what you're conveying to your staff and your organization and business associates and people, your patients, is a culture of compliance. If you can show a culture of compliance where everybody understands how to protect the data, you're going to pass. If somebody in your practice they walk up to them and say, so where is all your HIPAA information? Well, I think it's in that white binder over there. I don't know what's in there. But I've been told that's where HIPAA is. You're going to fail. We're talking about laptops, right? Talking about encryption, right? So here's a radiology oncology group that they lost a laptop, unencrypted, with all sorts of PHI on it, and they got $775,000. Now, if they could have documented that this laptop had been encrypted, and it was strongly password protected because they had an audit that showed that, this would have been nothing. Zero. But because they couldn't, and because they didn't, it's $775,000. It's a huge difference. Okay? So here, if my patients don't understand, my employees don't understand to do with information, okay? And I didn't train them, and they don't have policies and procedures about it, and they send out this information. Let's say it's in an email, and it goes to the wrong place, and it's unencrypted because they didn't know. I didn't teach them, right? This can happen to you. You can get $12,000 fine, and you don't even have a license anymore. Move to another state. You got to do something else. So because why? Because they didn't implement HIPAA correctly. They know about it. The rule's been in place for 10 years. Everybody knows about it. They know that they're supposed to do it. They don't do it. They don't think that HIPAA does have any bite, but I'm telling you, they're going to come biting. They're going to be like a wolf pack, too, because those people who are coming to do audits are probably going to have incentives. Here you have somebody that, remember I was just talking about the box at the person's feet at the front desk where all the paper from the EHR is going in there, right? So then what happens is, so you throw this EHR, you throw the EHR papers in there, and then everybody gets up and it's Julie's birthday, right? They all run out, woo-hoo-hoo. And then all of a sudden the cleaning service comes in. And they don't know that the office managers yelled at the cleaning service because the place looks like a mess. And they walk around and they see that box. And what does it look like? A box of trash. And it goes out in the dumpster. And then you end up with this because people found it. You end up with a $400,000 lawsuit, and who knows what HHS is going to fine you, because they're going to fine you per each patient that was in there. It is avoidable. Things are avoidable. Things you can avoid getting fined even if you have a breach. Because if you can show that you have all the things that I showed you in place, right, you made a good faith effort. It's just something that happened. It's a rogue employee. It's a situation that we didn't see, that we will address now. But if you can avoid it if you have all the things that I've talked about during this webinar. Mark, you still there?
All right. Yep, I'm here. Okay.
Okay, go ahead.
No, that's all right. You can just draw the next two slides. Okay, so a couple of slides we just want to cover in closing today are, one, breaches are dramatically on the rise. Okay, so if you compare to past years, the notifications that are going to HHS about, or OCR, about what's going on is dramatically higher. Okay, a lot of it's going on is that, going back to the beginning of the presentation, the average consumer is becoming much more involved, and a lot of people misunderstand that. They presume that the only time that someone can report you is if they're an employee or a patient, but really anybody walking by your office, if they see you do something that they think is an incident or they think is a violation, they can just call a phone call, go to a website, log an incident. It's a federal mandate. OCR is obligated, if it is reported to them that there was an incident, they are obligated to investigate. So we're seeing more and more of what is people who they're more informed because what they've been seeing in the market. So they're actually going out and reporting more and more incidences. So it is definitely on the rise. So Bob, if you can take me to the next slide. So in summary, this is one of the things we see as a challenge for you folks in the market is that you'll see pieces of solutions, and we just want to make sure you understand that the title of this presentation was how not to fail your audit. So there are lots of ways to be compliant. We just want you to be sensitive to the things you need to be doing, whether you are doing this yourself, if you're buying services from folks. You need to make sure you're not just doing it. Notice, let's say if you're just starting at the top, you need to be doing all of the audits that are called for, not just a risk assessment. Often we see folks that say, going to the initial example, I have policies, procedures, or training. Unfortunately, those without the remediation plans and, for example, the employee attestations, you unfortunately would fail an audit. Now that Omnibus is no longer, officially went into enforcement is the term in September of 2013. OCR is not being tolerant about in the stage 2 audits. One of the things that has been called for is in that stage 2 audit, they're specifically auditing business associates. And one of the interesting things that they said within that the way that the enforcement will be going forward is, if a covered entity fails an audit, they will audit its business associates. If a business associate fails, they will audit the business associates, either other BAs off them or the covered entities they serve. So they are really trying to tie this all together. So this is not just a matter of, the person who commented, this is a burden to the system. It starts with a simple premise. If you run your organization, think of it as a brand. Okay, and I use this example in some of the presentations we do. Why is a Starbucks cup of coffee the same everywhere you go? Because they have policies and procedures, they train their people, and they audit them. So it's really just a function. Look at compliance as a way to protect your practice and to differentiate itself. Obviously, incident management. There could be a lot of cost to this, but there are a lot of ways to do this in very cost-effective, logical ways, like I said, whether internally or externally. Bob, if you could jump to the next one. One more. Okay, so what you want to have is all of these services put together working seamlessly. This is the way you avoid an audit. And there are tools in the market to do this. We've seen some interesting ways that people have done this themselves. It does not have to, unfortunately, it can be cumbersome. So there are depending as organizations get larger, it can be tough for an organization to be able to address all these things. But ultimately, if you want to avoid failing your audit and you want to protect your reputation, which is what we think a lot of this is about, you really need to be thinking about a culture of compliance at the most basic level, that you and all of your employees and the folks you work with all address. Okay? Of course, now I got my phone ringing in the background. Okay, now I'm going to go back to some questions. Okay, so one of the questions that came through is there an insurance policy available to helps an entity with these fines?
It does not help. Well, here's the deal is, right? So yeah, you can get cyber, it's called cyber insurance, right? Where if you have a breach, but just like if you're driving your car and you are found to be drunk or in willful neglect, the insurance isn't going to pay for it. So it doesn't get you off the hook to comply. All it does is it'll help you pay if you were found not in willful neglect and something happened. So it's another level of protection, but only if you're complying with the HIPAA security rule. You're complying with HIPAA.
All right, so let's see. Next one. What is a physician's liability if the EHR company causes the HIPAA violation?
None. That's why you have a business associate agreement in place. So you have that business associate agreement in place, which tells them that that's why I always say the business associate agreement is like a contract, right? You're contracting with the EHR company. You contract with them that they are compliant with the HIPAA security rule, that if a breach occurs, they will pay for the breach. And that's why I said you will get business associate agreements that say, I'll pay for mine, you pay for yours. In that situation, if they say that you're going to pay for all of the breach notices and for the credit report, then that's what you're going to pay for. So you have to be real careful when you're signing somebody else's business associate agreement.
Next question is, encryption of data in transit does not guarantee access control, so who is responsible?
Okay, data encryption is not for access control, right? Data encryption is to protect the data as it is traveling from one site to another, whether it's internally or externally. Access controls is controlled by the security officer. Access controls by the security officer should be, okay, I look at this person within my organization, and this person's job description says X. So I'm only going to give this person access to X. Now, if this person needs additional access, I'm going to need their manager to tell me why should they get additional access. Okay, that's why you'll see people at hospitals. You'll see hospitals like UCLA Medical Center who have gotten fined because their floor nurses, the head nurse on the floor, has given everyone her login because she can do everything and she gets tired of doing it for them. So they're constantly asking her, hey, can you do this? Hey, can you do that? Because she only has the access to do that. And she gets tired of it. So what she does is she gives her access to these other people, and they're nurses, right? But they're not supposed to be doing what she's supposed to be doing. But she says, just do it. And so then they go over and do it. So guess what? They all get in trouble. They're all responsible. So access controls are based off of what are you doing, what is your prime function, what is your job, what does your job description say you should be doing, and you should only be getting access to that portion of the EHR system or hospital information system to do your job, minimum necessary, right? You always have to think that, minimum necessary. What is the minimum necessary you need to do your job? Not giving them carte blanche like in some doctor's offices. It's conceivable that everybody has the same access. Why? Because in a small doctor's office, they probably do everything. Everybody does everything, right? All hands on deck. But in a larger organization, it doesn't work that way. Everybody has their own job to do. So you have to be real careful when you're giving access to people.
Okay, next question. How do I get secure email, or how do I get my current email secure?
There are vendors. There are vendors that will set up We at Compliancy Group have vendors that we utilize that help customers do things like secure email, encrypted email from site to site so that you can send information protected, or penetration tests or vulnerability tests and things like that. They're not. You have to remember this too. People will say that people will come up to you and say, "Have you had a vulnerability test? You need to have a There's nowhere in the world does it say you have to have a vulnerability test. What it says is that you must protect the data. Remember this. I must protect. When you go back to your office, you're done here. You go out and you look around. I must protect the data. I must make sure that everybody understands our primary goal is healthcare, and our second goal is protection of the data. Hope I answered that.
No. Let's see. Although we are supposed to be paperless, we have reports and EOBs on different people's desks. How bad is that?
It depends. So you can have paper in your office, right? No, there's nowhere it says you can't have paper. Again, protection, right? How am I protecting that? How am I protecting it's not getting in the trash? How am I protecting it if I have a cleaning service and we leave the data out at night, right? So we've talked about business associate agreements. What we haven't talked about is confidentiality agreements. A confidentiality agreement should be given out and should be at your front desk for anybody who accesses your site, right? That confidentiality agreement should go to people like the copy guy, the fax guy, building maintenance, cleaning services, right? The sales guy who sits on people's desks and thinks he owns the place, right? Any one of those types of people, you should have them sign a confidentiality agreement that says anything you see, hear, or touch while you're at my site, you will keep confidential. And then you keep that confidentiality agreement so in case any of those people go rogue, like the cleaning service, you're not there when they're cleaning, they taking stuff you don't know, right? So if that happens, you're able to present that document to say, I address security with them. Right now, you're just going to go, I had a guy in here and he was cleaning. I just thought, right? I thought it was okay. You're going to think wrong to a large fine is what you're going to think.
All right, okay. Guys, we are a little past 3 o'clock, so why don't we get the last couple of questions in? We do appreciate you coming and spending time with us. We don't necessarily want to keep you away from your business days. Next question was, is it okay to email a patient their records if we just have standard Outlook email? If the patient requests a copy to be emailed to them and we tell them our email is not secure.
If they sign the agreement, if they sign something that says it's okay for you to send it unencrypted, yes, you can. Under the new, under high tech and omnibus, you can send that information, absolutely. But make sure you have it documented that they agree to it. Don't just take their word for it, because all of a sudden it goes to that email address and it's, I don't know, whatever it is, right? It's a cancer, and all of a sudden the husband opens the wife's email and sees that, and then she's upset at you because you sent it, right? You want to make sure you have that document that says, you told me I could. But yes, you can.
All right. Well, we have run out of questions. So if anyone has one or two last questions while I'm summarizing up, we do feel free to send them. If you do have more questions, you are welcome to contact either Barb or I. Our contact information is up on the screen, and we will do our best. We also do have the HIPAA hotline. Our telephone number is 855-85-HIPAA, and you would be surprised how many kind of odd calls we get from people who are just ask all sorts of HIPAA questions that are not in any way related to us as our clients. So we do try to answer them. If you are grappling in some of the things you saw in the shameless plug category, obviously Compliancy Group, this is what we do. We help organizations simplify their compliance by providing a tool, and what we have been recognized for being unique is that we created a tool that ultimately makes it so compliance is in your hands. Think of QuickBooks for compliance rather than the majority of the tools in the market address what an auditor needs to be working with, not necessarily with you. Let me see, I think we got one more question. What is the best way to organize current BA contracts for an audit?
By vendor and having the business associate agreement and the audit all in one place for each vendor.
All right. Well, hopefully you folks did find this useful, and just as a reference point, you can take what Bob and I have shared with you with great seriousness. We are pretty proud to say that even though we have thousands of customers, we've been through thousands of audits for OCR, hundreds of audits with OCR and CMS, we have never failed, none of our clients have ever failed an audit. So the things we're telling you need to be doing are really what you need to be doing. So we got one more. Why don't we take this last one? Regarding the confidentiality agreement, do we need to have individuals sign it each time they are at the facility? Not cleaning services, but maybe a copy service individual.
Each individual needs to sign it, but they only have to sign it once, right? It just carries on throughout the lifetime that they come to your practice, right? But you need to track that, right? So, so that you can show that you did address that with them.
Good. All right. Well, Bob, I think that is officially all the questions. Everyone, thank you very much for taking time out of your busy day to join us. We do hope that you will join us at the next webinar, which is October 22nd, and that's going to be protecting your online reputation. We'll be doing that. Doctors.com will be speaking. I really get a kick out of, or I find their application. They're kind of like, think of Yelp for the healthcare industry, and what they have to talk about what's going on with your online reputation is I think a very interesting topic. So thank you very much, Bob. Thank you, and everyone have a great day. Thank you once again for joining the Free Education Series.